English Legal Dictation, Exercise 23, ready, start. However, this fact is sought to be distinguished by the respondents on the ground that it was an appointment in an autonomous body and therefore it will not amount to any regular recruitment as understood under the absorption rule. We are unable to accept this stand in the counter affidavit inasmuch as the very letter of appointment of Shiv-Prakash Sharma itself refers to Senani Kalyan Parishad to be governed by the government order dated 23/12/2001 and absorption has been acknowledged on account of Shiv Prakash Sharma being a retrenched employee. Thus, there is no doubt that the absorption of Shiv Prakash Sharma was clearly on account of his retrenchment after he had withdrawn his writ petition. So far as the status of the Senani Kalyan Parishad is concerned, a reference to the office memorandum dated 12/2/1973 issued by the government of Uttar Pradesh would clarify the position. In Class 4 of the said memorandum, it has been categorically stated that the Senani Kalyan Parishad shall be government institution. In our considered opinion, the said organization, therefore, being a government institution as described in the office memorandum itself, negates the arguments advanced on behalf of the respondents that it was governed as a separate entity and autonomous body and not a government department. The absorption of Shiv Prakash Sharma was in a government institution. As such, no distinction can be drawn on that count in so far as the case of the appellants on parity for absorption is concerned. Coming to the question of applicability of the 2003 recession rules, suffice it to mention that the issue of absorption had already been raised immediately upon the corporation being wound up in the year 1999. Thus, the status of retrenchment was already being faced by the appellants and they had already raised their claims much prior to the enforcement of the recession rules 2003. The said fact is also fortified by the fact that the interim order was issued on 25/5/2000 directing the state government to consider the same. Consequently, the entire exercise had already commenced and the state government having failed to take a decision, the rights of the appellants had already crystallized and adjudication whereof has now been made under the impugned judgment. In such a situation, the conclusion drawn by the learned single judge that since the employees have been retrenched after the recession rules 2003, now here affects the rights of the appellants, whereas in fact the appellants were already facing retrenchment and they were entitled for consideration of their rights accrued earlier has already pointed out in the judgment of Vinod Kumar Kushwaha and other judgments in the connected writ petitions. Learned Standing Counsel for the state also informs the court that the aforesaid status of retrenchment and its effect has been discussed in a later decision of this court of a division bench after considering the impact of the earlier judgment in this regard, and in this view of the matter also the appellants would not be entitled to any such benefits. Stop.